Hello and welcome to the last video lecture in your program on Advanced Patent Law.
In this lecture, we will deal with patent commercialization. We will specifically discuss options for patent commercialization, which are manufacturing, assignment, joint venture, and licensing. What is commercialization? The term commercialization means generating income from an asset. Thus, patent commercialization would imply steps taken by a patentee to generate income from the patent. Patents have many functions. A company may own patents for defensive purposes or with the intent to hinder competitors' business activities. Alternatively, patents may be obtained for commercialization purposes. More so, in cases where an invention is to be publicly used, patents are obtained in order to prevent rampant copying later. Please note that the Indian Patents Act does not provide ways for commercializing a patent. So, what are the ways in which we can commercialize a patent? In fact, commercialization is completely dependent on two parties' requirements, negotiations, and what they bring on the table. Different ways commonly used to commercialize a patent are manufacturing, assignment, joint venture, and licensing. Let's discuss the first one, that is manufacturing. It is possible that the sole purpose of patenting an invention is to use such product or use such process in the course of business. The patentee commercializes its own patent without any dependency of a third party for negotiations.
It is one of the most straightforward form of commercialization. For instance, an entrepreneur will launch a company that sells patented products.
The next option for patent commercialization is assignment. In case of a patent assignment, the ownership of a patent is outrightly transferred, that is, the patent is sold and the patentee receives an agreed upon payment with no future royalties. The patentee may sell all or any part of the invention. It is preferable that other forms of patent commercialization should be explored first, and only if the patent is of no use to the company, the rights may be reassigned. The reason is that while a patent may not have a current application or the patentee may not discern it, the future could hold commercial opportunities unforeseeable today. Selling a patent may deprive a patentee of a potential fortune. It is important to note that in case any reassignment of an Indian patent takes place, it should be duly recorded at the Indian Patent Office. Section 68 and 69 make it mandatory that the assignment should be registered. In case such assignment is not registered, then the courts will not recognize the new assignment in case of a patent infringement. The next commercialization option is joint venture, which is when two parties chip in their resources to make a product. When such coming together is backed by patents from each parties, a joint venture that commercializes patents is formed. The parties may keep their respective patent rights and agree to license patents to a new entity formed via joint venture.
This is one of the most successful form of commercialization where the party pool in resources to form a joint venture.
Another route in the commercialization process is licensing, through which a patentee retains ownership of the patent while allowing another party to make, use or sell the invention. In exchange, the patentee receives royalty payments. All available forms of licensing can be employed, which are sole licensing, cross licensing, exclusive licensing, non-exclusive licensing, and compulsory licensing.
Let's understand each type of licensing by way of illustration.
The first is sole license. Let's say A, the patentee licenses patent rights to B via sole license. Only B can avail the patent rights for the term of the licensing agreement. The next one is cross license. A and B both have patents to their credit. A and B license some of the respective patent rights to the other party via a cross license. In this scenario, both A and B can avail the rights of the licensed patents for the term of the licensing agreement. The next type of licensing is exclusive licensing. A, the patentee, licenses patent rights to B via an exclusive licensing. Both A and B can avail the patent rights for the term of the licensing agreement, but the patentee A cannot license rights to anyone else after giving exclusive rights to B. Another form of licensing is non-exclusive licensing. Let's say A, the patentee, licenses patent rights to B via non-exclusive license. In this case, certainly B can avail the patent rights for the term of the licensing agreement, but A is free to license the patent to other parties too. Please note that the terms of the agreement with B do not impact the terms of agreements with other parties. The last form of licensing is compulsory licensing. This form of licensing is provided to check on a patentee from overexerting his or her rights. It is provided under Section 84 and Section 92 of the Patents Act. The request for the grant of a compulsory license can be made by filing an application with the Indian Patent Office, and subject to fulfillment of certain conditions provided under Sections 84 or 92, it can be granted. Section 92 vests this power with the central government to initiate compulsory licensing proceedings, while Section 84 requires a person to file an application for compulsory license.
Let's understand each method one by one.
Section 84. Under this section, after the expiry of 3 years of a patent grant, a person interested can file an application for a compulsory license on one or more of the following grounds. 1. The reasonable requirements of the public are not being satisfied. 2. Patented article is not available on reasonable terms. 3. The patented invention is not worked in India. For instance, if the patented invention is imported rather than manufactured in India. After studying the application of the interested person, if the controller is of the view that the application meets the requirements laid out in the Patents Act, the controller may grant a compulsory license.
The controller will specify the royalty rate and the terms and conditions of the license.
Section 92. As per this section, the central government can notify in an official gazette that a compulsory license should be granted on a patent to work the invention. The central government can make such notification in circumstances of national emergency or extreme urgency or public non-commercial use. The notification can be made at any time after the grant of the patent. In response to this notification, an interested person may apply for a compulsory license, and if the controller finds the case fit for license, the controller may grant compulsory license to the person. It is also required that the controller should lay the terms and conditions of the license agreement and endeavor that the goods are available at lowest possible price to the public. Given that no interpretation has been provided in the patent manual or otherwise for the terms national emergency or extreme urgency or public non-commercial use, one should interpret them as what they commonly mean. So far, no license has been granted under this section. It is recommended that the patent manual be referred for further explanation on compulsory license, grounds, and the procedure. Besides the above forms of licensing, the Patents Act mentions some restrictive conditions that should be avoided. Some of them are: 1. Tying arrangements. Consider this: A gives license to B for selling a printer on condition that B will sell ink cartridges made by A.
This is a tying agreement where one product is tied with another, which is unlawful.
Next is exclusive grant back agreements. For example, A licenses B a vending machine. While using the vending machine, B makes some improvements. If A's agreement includes a clause that all improvements relating to a vending machine by B will be transferred to A, then such a grant back agreement is unlawful.
It is advisable to study Section 140 to make sure that there are no restrictive conditions.
With this, we come to the end of our lecture. We also come to the end of our advanced program on patent law. We hope you found the program useful.
Please remember to check the discussion forum for the dates for the term and examination, and please do the practice exercises for each unit.
Please note that our other programs and articles on various areas of law are available on mylaw.net. Best of luck for your exams. Thanks for watching.